Good evening and welcome to the CondoWise Learning Series, session number 13. Today we're going to explore COVID-19 vaccination passports and ask the question, will they work? We're actually going to take on some very specific questions, but I'd like to advise you that this is not legal advice. We're giving you our reflections, our experiences, and our thoughts, but every condominium community is unique. So we strongly recommend that you actually speak with your lawyers to ensure that you get advice that is applicable to your community. So thanks for joining us. Today I'm happy to have with us a panel of speakers. Next slide, please. Can we advance the slide? Sorry, I think we're having a few internet issues. With me today is Julia White, Jonathan Wright, Ashley Winberg, and Shannon Penny from our team at Aaliyah Associates. So we're going to jump right into it because we have an hour and we have a lot to cover. So the next thing is a pandemic update. So Shannon, why don't you take it away?
Perfect. Thanks very much, Patricia. So good evening, everyone. As I'm sure you are all aware, Ontario is currently in step 3 of its reopening plan. And as of today, over 86% of the population in Ontario aged 12 and older have received at least one dose of the vaccine, and 81% have received their second dose. So the province previously stated that we would remain in step 3 until at least 80% of the eligible population had received one dose of the vaccine and 75% had received their second dose. However, in response to the evolving data around the Delta variant and based on experiences of other jurisdictions, the province decided to pause exiting step 3, and all existing restrictions will remain in place until such time that it is deemed safe to exit step 3. So last week, Pfizer submitted introductory data from their trial for a COVID vaccine to Health Canada for children between the ages of 5 and 11 years old. A formal filing of the submission for authorization is expected around mid-October. So on October 22nd, the Ontario government introduced the vaccine passport. Ontario residents need to either print or download their second dose receipt from the government website until the enhanced certificate becomes available on or around October 22nd. A receipt from another jurisdiction will also be accepted. Proof of vaccination will be required to eat indoors at restaurants, bars, to enter the gym, movie theatres, nightclubs, sport venues or concert, and to also use large meeting and event spaces. Adults over the age of 18 are required to show a physical copy of identification alongside with their proof of vaccination, whereas youth between the ages of 12 and 18 can use a photocopy or a digital version of identification. Proof of vaccination is not required if you're simply using the washroom or you're paying for a takeout in an indoor establishment where vaccination is mandatory. It will also not be required at essential services, including grocery stores, religious services, pharmacies, and banks, and it's also not required to enter a hair salon or the shopping mall. Exemptions are also given to those who cannot be vaccinated for medical reasons and for children under the age of 12, who as of right now are not eligible to receive the vaccine in the province. So Ontario's Chief Medical Officer of Health announced today that a new targeted COVID-19 rapid test program will be introduced in schools and licensed childcare settings. So starting next week, local public health units will be able to send rapid antigen test kits to schools deemed high risk. And the rapid test will be used only for unvaccinated children with no symptoms who are not high risk contacts of a COVID case. So as I'm sure some of you are all aware, the Ontario government updated its symptom list on August 26 and removed a runny nose from the list of symptoms. The most common symptoms of COVID-19 that I'm sure all of you are aware that require immediate self-isolation and a COVID test include fever, a cough that is new or worsening, shortness of breath, sore throat, or a decrease or loss of smell or taste. And also some other symptoms to be mindful of in adults over the age of 18 can also include fatigue that is unusual or not related to another known cause or condition, and also muscle aches and pains that are unexplained, unusual, or long-lasting. So individuals who are experiencing COVID-19 symptoms should immediately be tested, regardless of your vaccination status. If you have not been fully vaccinated, you will be required to self-isolate for at least 10 days if you are exposed to COVID-19, even if your test returns negative. It's also recommended by the province that you take another COVID test on or after day 7 of your self-isolation process. If you were fully vaccinated at the time you came into contact with someone who tested positive for COVID, you will not be required to isolate unless, of course, you are experiencing COVID-19 symptoms. And the same applies if you have tested positive for COVID in the previous 90 days and have been cleared from the infection and are free of symptoms. Again, a test is still recommended. If you are asked to self-isolate as you're experiencing COVID-19 symptoms, but you are fully vaccinated or have tested positive within the previous 90 days, you may end self-isolation after you have received a negative test result and once your symptoms have been improving for at least 24 hours. If you are experiencing stomach issues such as nausea, vomiting, diarrhea, or stomach pain, the symptoms need to be improving for at least 48 hours. So if you do require some more information, the Ontario government website provides further details regarding self-isolation. So thank you, and I will pass you now back over to Patricia. Thank you.
Thanks very much, Shannon. That was very comprehensive, and I appreciate you taking the time to summarize that. So some new shifts, even since the last announcement on the 22nd of September. So as we know, the Ontario government resisted the whole idea of COVID passports, but they had to give in. And why do they have to give in? Obviously, you know, there's a need to get our economy and our world in Ontario back on track. I don't think we can afford another lockdown, and I don't think lockdowns are proving to necessarily be successful. If you look at New Zealand, New Zealand is still in a 7-week lockdown, and the variant is spreading rapidly there. And so they have to really look at their own solutions, and they only have a rate of 12% of vaccination for their country. In Ontario, we're doing better than that. And it seems like with the COVID passport, vaccination rates are going up and our numbers are going down. So interesting correlation, interesting way to push public policy. As you may know, Regulation 36.4/20, the rules for areas at step 3 and at the roadmap exit is the regulation to review in order to understand where we have to implement different strategies, perhaps with respect to COVID passports. So we have a poll, and I'd like to ask you a few questions for those of you who have joined us tonight. If we could have the next slide, please. There you go. If you see on your screen now the CondoWise poll questions, do you think COVID-19 passports are a good idea generally? Do you think COVID-19 passports will work in Ontario to reduce the spread of COVID? And do you think condos should use COVID-19 passports? While you're answering that, you know, I think it's important to understand and appreciate what Shannon was talking about, where there are exceptions or where the regulation won't apply. It's for things that are essential, like retail, grocery stores. My thought is that our homes are essential. And so we really need to be thoughtful as to where these rules and how they're implemented in our community make the most sense. It really is about transmission reduction. It really is about being aware of how complex condominiums are. They're not just residences, though. They're also workplaces for legislative purposes. So we really, when we're analyzing it, we need to take that into account. And again, legal opinions, advice from your professionals is important. So maybe we could see the results of those polls now. All right, so the majority of us think that COVID passports are a good idea generally. Do you think that the COVID passports will work in Ontario? Yes. And I can't see the last set of answers. Let me just scroll down.
Scroll down.
Yeah, there you go. Do you think condos should use the COVID-19 passports? Yes. Okay. So thanks for our panelists. This is of benefit for you when you're looking at, some of the views in the room. So you can definitely think about that as we go through. So now we're really excited to have some very specific questions answered for you by Ashley Winberg. Ashley, as you know, has a specialty in employment law, dealing with labor issues that unionized environments and contractors. In her practice, she does a lot of the review of these elements, plus the development of policies for condominium corporations. So thanks, Ashley, for being here. And we've set up a list of questions. I'm just going to take you through those questions and let you go to it. Is that all right?
Sounds good. If we can go to
All
the
right.
next slide, please. Thank you.
So on the employees and contractors front, can a corporation require its unvaccinated superintendent to get vaccinated? And the second question is, if a corporation's unvaccinated superintendent refuses to get vaccinated, can the corporation terminate their employment?
So this is a question a lot of our clients have reached out to us with. So answer to the first question is no. No employer can ever force any employee to get vaccinated because individuals are entitled to their own bodily integrity. An employer cannot, physically force someone to undergo physical treatment or intervention without informed consent. So the real question is, excuse me, if your direct employee superintendent, and let's presume in the first instance, they are not part of a union, so there's no collective agreement. They refuse to get vaccinated and your corporation wants all employees on site to be vaccinated. Can you terminate them? Yes. However, the real question is, how much are you going to have to pay them or provide them with pay and or notice? So employees who are not unionized can be terminated at any time without cause. However, if the corporation were to terminate them, they'd have to provide them with reasonable notice of termination, either in accordance with the ESA or the common law. And based upon the vast majority of superintendent contracts that I have reviewed, very few of them actually limit the employees' entitlements to the ESA. So it's likely going to be the common law, and how the length of notice they're entitled to will depend on a variety of factors. So yes, you can if they're a non-unionized employee, but you are likely going to have to pay them a considerable chunk of change. Now, if they are unionized, and a lot of security staff and cleaning staff in condominiums are unionized, the answer would be no, because in unionized contexts, in unionized workplaces, you cannot terminate without cause, generally. All my answers this evening are general in nature. So no, in that particular instance, you would not be able to. So if your corporation is implementing a policy, check with your solicitor to find out if the employees on site are unionized or not unionized. Next slide, please. Sorry, I thought Patricia was going to ask me the question. I'll continue. So if your corporation is considering implementing a rule or policy requiring all of its employees and on-site contractors to be vaccinated, and an individual advises the corporation that they're exempt under the Human Rights Code, what should your corporation do? Well, it is possible that someone could say that they are exempt on the basis of 3 grounds. The first would be creed. The second would be a medical reason, and the third would be a disability. So I think it's on September 22nd, the Ontario Human Rights Commission released a policy on COVID vaccinations and proof of vaccine certificates. And essentially, it was great that they released this policy because it provided a lot of clarity to lawyers in the industry and employers. One thing that the commission noted is that they were in favor of mandating and requiring proof of vaccinations to protect people at work and people obtaining services, as long as there's adequate safeguards in place to ensure that people who are unable to get vaccinated for a code-related reason are reasonably accommodated. So with respect to that first category of a code-protected ground, CREED, in this policy, the Human Rights Commission said that CREED, in this particular instance, would not be if someone has a personal preference that they do not want to get vaccinated, or their singular beliefs of not wanting to get vaccinated would not amount to CREED for the purposes of the Human Rights Code. So if someone has a personal preference that they do not want to get vaccinated, they will not be entitled to accommodation under the code as stated by the Human Rights Commission.
So Ashley, with respect to
Hmm.
CREED, hasn't it been held in the past that you have to have evidence of a deeply held belief? But that is in the context of something larger. Usually it's, for example, religion is one of those things that when we're looking for religious convictions, for example, the need to have a Shabbat elevator, we're looking for evidence or history to support that. But what you're saying is that the deeply held belief that you don't need to have the vaccine is not going to be considered the deeply held belief?
Well, I'm saying that the Human Rights Commission has said it's not going to be a CREED for the purposes of the code. The Human Rights Commission didn't answer whether or not it could constitute religion or for which you might be entitled to exemption. They said just not CREED.
Okay, so it doesn't necessarily, it's not really within the definition of, it could be part of religion. Is that what you mean?
I don't know. It's up to debate.
Okay.
It's up to debate.
Sorry, and I was going to
opined on that.
I was
Yeah.
going to ask the questions. I was just answering Bill in the chat
Sorry.
when we changed slides. So if a corporation creates a rule or policy requiring all of its employees and contractors to be vaccinated, does that rule or policy have to offer COVID testing as an alternative?
So that sort of gets me back a little bit to the prior question, because I haven't finished answering that yet. So in addition to CREED, people can also be exempt for medical reasons, medical exemptions, which Julia will discuss later on in the webinar. And the Human Rights Commission has essentially said the documentation that someone would have to provide in that instance is exactly what the provincial regulation provides, which Julia will discuss later. And the commission also noted that disability-related needs would also be a valid exemption. So if someone is exempt under the code for a vaccine requirement due to a prohibited ground, yes, testing would be a reasonable form of accommodation. Now, does any policy or rule created by a condominium corporation need to have testing as just an option? Not necessarily. However, if a corporation was going to create a rule, rules have to be reasonable, and it would make the rule more reasonable. However, as stated by the Human Rights Commission, if someone needs to be accommodated by way of providing negative testing, or if it's incorporated into the rule or policy, the cost of the testing should be paid for by the condominium corporation, or whatever organization.
So that's not considered undue hardship on the corporation?
No.
Okay. No. All right. So in terms of the next question that I referred to, in dealing with this alternative testing, is every test that's an alternative test going to be acceptable? Because I've heard that in the airline industry, if you don't get a certain test, it's not good enough. So how are the distinctions to be made, and is there any suggestions on research that needs to be done?
Well, I think it's really up to whatever corporation is creating this policy or rule. I know for the TDSB, for instance, for my son, I can't submit a negative rapid test done at home. That's not sufficient for TDSB purposes. Under the TDSB's policy, they require either a test done, the regular COVID test, or a spit test. A rapid tests are not accepted. So it's really up to the condominium corporation. However, the at-home rapid tests, I'm sure there's sufficient amount of room for error there. So a corporation may want to rely on tests verified by professionals.
Okay, great. Thank you. So ladies and gentlemen, as well, we have the opportunity to ask questions at the end, but if as you're thinking about questions, please put them in the Q&A and we'll try our best at the end to get to them. So next question, what privacy rights do employees have when it comes to disclosing their personal medical information, such as their vaccination status or COVID test results?
So when you and I, Patricia, were first discussing this issue, I think in July, we were both really quite concerned about the privacy issue. And researching this matter further and all of the statements made by government officials and public health units, recommending that all employers and organizations implement vaccination policies for the purposes of protecting their employees pursuant to the Occupational Health and Safety Act. I am now of the opinion that in Ontario, there's really nothing in the law as it currently stands to protect an employee from a bona fide requirement to have proof of vaccination or negative testing. In Ontario, we have our federal PIPEDA, the Federal Information Protection and Electronic Documents Act, and a similar provincial regulation. And we also have the Personal Health and Information Protection Act. However, PIPEDA and the provincial statutes similar to it only apply to federal and provincial works. The Health Information and Protection Act, that applies to how health information is used, collected, and disclosed within the health sector. It applies to healthcare providers and quote unquote health information custodians. So technically not employers. So a vast majority of employees in Ontario are without protection when it comes to provincial privacy legislation, when it comes to the information in their employer's hands.
But I think as well, condominiums under Section 55 have an obligation to keep confidential the information of their employees. And I also think that condos need to think about how much risk they want to take in collecting and disclosing information, and that an information policy putting restrictions or boundaries on that is probably very important for a condo corp. So
100%. But I think here it's the risk, because the risk of the Delta variant has become a much more greater social concern. It's sort of outweighing the privacy rights of the individual in this particular instance.
Right, for the greater good, I guess.
Yeah.
So can a resident deny a corporation's contractor from entering their unit to perform work for the corporation if the contractor refuses to provide the resident with proof they are vaccinated? Now that's a loaded question.
So this is actually a question I got asked to opine on for an article I'm writing for an industry publication. I don't like this question because there's no straight answer. Okay, so first off, if a resident can request that from a contractor, the contractor can request the same thing from the resident. Ideally, you want your condominium corporation to have policies in place from the get-go, which I'll be discussing a little later on, so that residents have a reasonable expectation of the due diligence conducted by the condominium in advance. Now, if there was a flood and you require immediate assistance, the corporation might not be able to, number one, they might not have a policy in place, and that's fine, it's up to the board. But if they do, they may not have been able to vet the individuals attending the site to assist. So there's really no yes or no answer to this particular question. It all depends on the circumstances and how much time in advance the corporation had prior to this individual knocking on the resident's door.
So you said something interesting though, but it seemed to imply that there's an obligation both ways.
Yeah, 100%. There's nothing in the law, but it would be reasonable to assume that, because if a contractor can expose a resident, if they're in the unit at the same time, can expose a contractor.
So any practical suggestions on how we can avoid sort of the conflict, but still fulfill the duty of, repair and maintenance, because work still has to get done?
Definitely. And I'll talk about that a little later on when we talk about some considerations for corporations to take into account prior to implementing anything.
Okay, great. So stay tuned, ladies and gentlemen.
Yes.
So the next one, next area that we're going to talk about are amenities. And Julia from our team is going to take on the questions on the screen. So, Julia, can we require the users of condominium amenity areas to be vaccinated? I'll give you the toughest question because you're the youngest lawyer on the panel.
So here we go. So Ontario Regulation 364/20 imposes an obligation on businesses and organizations to provide proof of identification and proof of vaccination prior to entry for patrons entering a premises. The regulation fails to define a number of terms, including patrons, and uses confusing and inconsistent terminology. Specifically, in some sections, it refers to persons responsible for businesses and organizations, but then in other sections refers to persons responsible for businesses or places. There's also no definition of recreational amenities in the legislation, which arguably would include a condo's amenity spaces. So the inconsistencies and lack of defined terms in the drafting has created some confusion and a degree of uncertainty as to whether this legislation actually applies to condos. In our view, the purpose of the legislation is to reduce transmission of the virus in places where people will be congregating. The government's focus is on higher risk indoor public settings where face coverings can't always be worn. So with this logic, there's really no difference between, say, a commercial gym and a gym in a condo. There are some arguments that can be made to suggest that the regulation applies to condos and some that it does not. The answer is really not straightforward. So due to the inconsistencies in drafting, there was a need for clarification, and a statement was issued by the representative of the Ministry of Health last week on September 28th, who stated that the regulation does not apply to condos, and specifically that facilities in condo buildings that are not open or accessible to the public are likely not public settings or facilities that would be subject to proof of vaccination. However, the ministry advised that condos may implement their own rules respecting the use of gyms or meeting or event spaces. So the ministry's analysis doesn't really take into account the fact that condos are multifaceted, as Patricia mentioned earlier. There are workplaces, private residences, and arguably organizations. Condos are also used to hold events where non-resident guests are in attendance, so members of the public. We note that this analysis also doesn't change the legislation. It was provided as a form of guidance. A reasonable precaution for boards to take, in our opinion, is to ensure that those using certain indoor amenity areas, such as the gym, pool, party room, and games room, be fully vaccinated in accordance with the regulation, but not for outdoor amenity areas, such as the rooftop terrace. We would also strongly recommend that all condos implement a clear vaccination policy to address the discrepancies in the regulation and to clarify what is expected of owners and residents and how access to amenity areas will be granted, if at all. Some condos may choose to simply keep their amenity areas closed for the time being. So where proof of vaccination is required, the condo will need to determine the best way to manage access to those amenity areas. For example, turning off access on each resident's fob to all amenity areas, and then only providing access and turning those fobs back on for those who provide proof of vaccination to the condo. This would only need to be provided on a one-time basis and then could be noted in the condo's records. Also, because transmission is still possible even where everyone is vaccinated, all protocols, policies, and rules currently in place for each amenity area, such as mask wearing, sanitization, the use of waivers, those should all remain in place until the government and public health officials deem them no longer necessary. Finally, all private information, as Ashley just discussed, should be managed in accordance with relevant privacy laws. We recommend that each condo implement an information management and privacy policy if it doesn't already have one in place, which will dictate the collection, use, and disclosure of personal information that is collected from residents, guests, and employees and agents of the condo.
Wow. Well, thanks very much, Julia. Very comprehensive. So what about medical exemptions? Are there such things?
There are two medical exemptions. So each condo should review and make sure that all of its agents and employees who will be reviewing and managing proof of vaccination for the condo, and therefore proof of medical exemptions, understand the specific requirements of each. So there are only two that the government has approved and that will be recognized. The first is a severe allergic reaction or anaphylaxis to a component of a COVID-19 vaccine, which must be confirmed by an allergist or an immunologist. And the second is myocarditis or pericarditis after receiving the first mRNA vaccine. And this must be confirmed via documentation from a physician or a nurse practitioner. And any exemption documentation must clearly indicate the reason why the individual cannot be vaccinated, and then the effective time period for the medical reason. So if it's temporary or permanent.
Great, thank you very much. So can we require all non-resident guests who are attending a function in one of the amenity areas to be vaccinated?
So the short answer is yes. You can require all non-resident guests to provide proof of vaccination. Those with a valid medical exemption who provide proof of the same should also be permitted to attend. Where an individual does have a valid medical exemption, the condo may also require the individual to provide proof of a negative COVID test prior to entry. But this should be made clear in the condo's policies and rules so that any necessary arrangements for COVID testing and documentation can be made prior to the event.
Great. And so in the sort of the context of how these things apply, should we permit residents to rent out the party room for a child's birthday if the majority of guests will be under the age of 12 and as such will not be vaccinated?
So our recommendations at this time would be in line with what the government is permitting and recommending. So currently children under the age of 12 are not required to be vaccinated and therefore not required to provide proof of vaccination. However, this may change in the future. So if and when the government mandates vaccinations and proof of the same for children under the age of 12, the corporation should follow that mandate and any other guidance provided by public health. But to answer the question, yes, you can permit residents to host a children's birthday party in the party room. Proof of vaccination should not be required for those guests under the age of 12, but should be required for any guests over the age of 12 who will be attending. Likely if there's children there, there will be parents and people over the age of 12.
Yeah, one would hope. Otherwise, we could have different issues in the party room. Thank you very much. So if we could have the next slide. So now we're going to talk about implementation considerations. So Ashley, why don't you take it away and give us an overview?
Now you can hear me, perfect. So this entire time we've been talking about vaccination policy or vaccination rule. What's the difference? Well, a rule can be enforced under the Condominium Act. Policy cannot. So if the corporation is going to require that users of certain amenities or its employees be vaccinated or provide negative test results, that should be outlined in a rule. However, the corporation should also have a supplementary policy to that rule, which would set out the procedures to be followed by the corporation. And so in that particular question that I answered a little while ago, or kind of answered, about a resident prohibiting a corporation's contractor from entering their unit, if a corporation had that vaccination policy in place and provided it to all of owners and residents and contractors and employees, that provides everyone with a better understanding of what to expect. And hopefully issues like that can be addressed prior to the contractor showing up and knocking on the individual's door. There's also a couple supplementary policies that corporations should have in place, which Julia and yourself, Patricia, touched on. And those are a human rights policy, as well as an information management and privacy policy. Now, if your corporation already has these policies in place, I would recommend that you get in touch with your corporation solicitor to ensure that they're updated to reflect any vaccination or proof of vaccination or testing requirements that your corporation might be implementing. And if your corporation doesn't have these policies in place, I highly recommend that you contact your solicitor to have these policies created. I know our office does them, all of our policies, for a very reasonable flat fee. Now, in terms of amenities, which Julia discussed, a lot of party rooms and pools, are subject to reciprocal agreements or shared facility agreements. So if your corporation wants to require that all users of the indoor pool be vaccinated or show proof of negative test results prior to using the pool, you better make sure that the other corporation or the other corporations that use that facility are on board with that. So that's something to keep in mind. Sorry. Oh, yes. Another thing in terms of contracts. So there was a question in the Q&A about who's required to pay for the negative testing if a superintendent is employed by a service provider or the corporation. So going forward, for all of your contracts that your corporation enters into with service providers, it is recommended that you ensure, vis-a-vis having the contract reviewed by your solicitor, that provisions are in place if your corporation wants to ensure that all on-site personnel dispatched to your site are double vaxxed or provide negative testing results to their employer. And something that a lot of us are forgetting about, but in terms of cleaning staff in particular and security staff at condominiums, there's a lot of barriers to people accessing vaccines. Although vaccines are readily available across the province, there are some barriers that still persist that make it difficult for people to get vaccinated. For instance, some low-wage workers have multiple jobs, so your cleaning staff might have two jobs, and they may be a single parent. So they may have a difficult time taking time off work to get vaccinated, or language barriers also prohibit people from getting vaccinated or access to a computer, the internet. So it's really recommended that corporations provide their direct employees with paid time off. Currently, the government under the ESA provides employees with 3 paid sick days until the end of the year related to COVID-19. But for instance, if your cleaning person has had to take some time off because their kid's been sick, they haven't been able to go to school, they may have already used up their paid sick days. So it would be worthwhile providing them with that paid leave so that they can get vaccinated. And that's sort of the end of my tips. I'll turn it over to Patricia now.
Okay, well, in terms of, allowing people the time, I know that at our firm too, we just found it so efficient to let people, take the time off and just go get it done because the lines were shorter at certain times during the day. So it could even be much more efficient for your staff in the long run. So what we're going to do is I noticed that we have questions and some of them have been answered, but I'm going to go back and address all of them and hear from our panel on those questions. But before we go there, I'm going to ask John to give us a case law update. John? Thanks,
Patricia. So we haven't had many cases or any cases at all concerning condominiums and vaccine passports or vaccine requirements. And I'm going to turn it back 6 months to where we had our first case that came out of a condominium in Burlington that dealt with masks, and then talk about another case that followed it. And you might be thinking, well, mask is a bit 2000, and we've been a year of masks now, and why are we going back to that? But I'll tie it back in at sort of the end of what I have to talk about. So the first case was HCC 77 in Mitrovic, and as I mentioned, it was a condominium in Burlington. The case involved 2 seniors, a gentleman who was 72 years old, a woman who was 72 years old, and a gentleman who was 68 years old. They were the owners of a unit in a high-rise condo, and to get to their unit, they presumably had to travel through the lobby, in the elevator, and through hallways to get to their unit. They were observed not wearing proper face coverings while in the common elements of their building, and each saying that they covered their mouth, nose, and chin was not possible due to medical conditions that they had. They refused to provide the condo with any medical evidence when requested, and at least one of the individuals was seen in the building on floors other than the floor they resided on, not wearing a mask, wearing an anti-mask sign around their neck, and posting anti-masking posters around the common elements. So the condo did what it had to do, and it sought compliance with its mask policy. And it argued that to travel in the common elements without a mask was a dangerous condition, as such as described under Section 117 of the Condo Act, and required the mask to be worn. So during the court hearing, the condominium was represented by a lawyer, and the individuals who were not so keen on wearing masks were also represented by a lawyer. The lawyer for the condo made arguments to the effect that the doctor's note that one of the individuals had submitted, although it referred to health issues, there was not any real evidence of a disability contained in that note. In fact, the doctor's note was basically a few words long and stated that Ms. Mitrovic was unable to wear a mask or a face shield due to health problems, and that she would vaccinate for COVID as soon as she could. So we have no real description of why or what consequences would arise as a result of wearing a mask or a face shield, just that she had problems and couldn't wear a mask. The other owner didn't claim any medical exemption up until and including the first hearing date, but he did file an affidavit for the second hearing, indicating that he had a medical condition such that he experienced difficulty breathing when his nose was covered, and that he felt he was going to pass out if he had to wear a mask for more than a couple of minutes. So we had a first hearing, which was what we call an injunction hearing, which is really relief that's sought on an urgent basis because there's an urgent matter that has to be dealt with. And in that hearing, the lawyer that the Mitrovics and her husband had retained, that was reportedly funded by a civil liberties charity, argued that he was nonetheless, despite not providing any medical evidence, was required, could not be required to wear a mask, and he was entitled to be exempt, notwithstanding the fact that no proof of a medical exemption was issued. They argued that it was not only necessary on the provincial level, but it was actually strictly prohibited by the municipal bylaw that was in place. The judge granted the interim injunction and required the unit owners to wear masks until he could consider the evidence and submissions at a further hearing and render a final decision. In part two, when we look at the final decision of this, the court ultimately held that the Condominium Corporation had no right to require the unit owners to prove their exemption. The court relied very heavily on the regulations that were in place at the time and the Burlington bylaw that stated that proof of a medical condition or exemption could not be requested, and that the exemption in the bylaw trumped the rules and the policy of the Condominium Corporation. The judge admitted that there was very little evidence from the condo owners in question that they couldn't wear masks, and that they couldn't in fact require any better evidence, that the condo couldn't require any better evidence. But at paragraph 45 of the decision, the court held, the judge wrote, on the other hand, HCC 77 has the right and indeed the obligation to insist upon conduct by its residents that does not place the other residents at undue risk, and that no person is an island. To echo the words of Justice Stinson, where someone chooses to live in a condominium community, whether as an owner or a tenant, they need not enjoy the unlimited freedom to do as they please. Rather, they must conduct themselves in accordance with the rules of the community and with due respect and consideration for their neighbors and fellow residents. Further, they must govern and limit their personal activities, taking into account the impact of those activities upon other residents as regulated by the condominium rules. And for that reason, Ms. Mitrovic and Mr. Zupanik were ordered to wear masks unless they were on a direct path from their door to the unit. So they could not wear masks. They could choose not to wear masks for egress and ingress from their units only. So if they went on to another floor of the Condominium Corporation, they had to wear a mask. If they were in an area that was not conducive to ingress or egress, they had to wear a mask. And to put this decision into its sort of troubling context, the Condominium Corporation pled that there was a dangerous condition as described under Section 117 of the Act. And then on the other hand, the court seems to acknowledge that that dangerous condition existed because of their refusal to wear the mask and the dangers associated with transmission of COVID-19. But the court seemed to limit that dangerous condition to only being dangerous when you weren't ingressing or egressing from the unit. It was nonsensical and certainly caused our office a lot of debate. Maybe debate's the wrong word. We all agreed that it was a nonsense decision. And that, if anyone has taken part in any discussion between Patricia and I, it's an unusual thing that we would agree on anything. But we both we both agreed that it was a nonsense decision. There was, in further to that, there was no evidence to suggest that the unit owners only had a condition that kicked in after a certain period of time when masks are worn. So, for example, there's nothing in the decision that states that where masks are worn for a period of 5 minutes or longer, these individuals suffer severe medical conditions. So this decision, and certainly in my opinion, seemed to infringe actually on both the rights of the unit owners and on the condo's ability to require a mask to be worn. It didn't really help anybody. Having said that, what the court did do that was helpful is it confirmed that the board had the authority to make and issue a mask policy. And we've heard Julia, Patricia, and Ashley talk very knowledgeably about what policies are and what rules are. In this decision in Mitrovic, it confirms the board's authority to make and issue mask policies. It also confirmed that the enactment of health-related policies during the COVID-19 pandemic was an appropriate exercise of the corporation's authority. And then it goes on to say that the efforts of this board to develop and circulate the mask policy were not only reasonable, but necessary in the circumstances. So here we have a framework that the court is outlining that provides a condominium corporation with the basis to make and issue policies. And it goes as far as to really say that they're required to do them. Required to do so. The efforts of the board were necessary and reasonable. Thankfully, after this decision was issued, we had a more sensible decision issued about a month later. It was an Ottawa condominium corporation, and it was in the case of Yakovlev and CCC 32. There's a high chance I'm butchering all these names. I have a habit of doing that, but I think it's pronounced Yakovlev. We have Mr. and Mrs. Yakovlev live in a unit with 4 of their 5 children. This particular decision, I believe, this hearing was heard in May of this year. But since the prior November, the Condominium Corporation had been attempting to address behavior on the part of the respondents and their children that the corporation claimed contravened the Condo Act and the corporation's governing documents and the mask bylaw, the bylaw being the Ottawa bylaw. There was a lot of sort of collateral to this decision. There was allegations of noise concerns and other behavioral concerns, but I'm just focusing on the mask issues. The mask bylaw and issue required, with certain exceptions, each person to wear a mask that covered their mouth, nose, and chin when they were in an enclosed common area of a condominium. The respondent's evidence, so the unit owner's evidence, describes a number of occasions in which, the condo's evidence described a number of occasions in which the respondent's children were seen not wearing masks while in the indoor common elements of the corporation. And the Ottawa's bylaw office had been called to CCC 32 on multiple occasions, and it issued warnings to the respondents. Interestingly, the instances of non-compliance with the bylaw were not denied by the respondents, and that Ms. Yakovlev actually stated in her affidavit that there were times that she admitted not wearing a mask because she had just finished eating. And she also stated that because of stomach problems, she must eat many times a day, and that she often ate on her way in or out of the building. I don't know whether that,
John.
Pardon?
It's believable, isn't it?
Well, I thought you were going to tell me to be careful, and I was anticipating that. I don't know how legitimate that concern would be, but the court did not find that she was claiming a medical exemption from wearing a mask. It seems that she may have just stopped short of claiming a medical exemption. I don't believe they were represented, and maybe if she had had a lawyer there, a lawyer would have told her, just say you've got a medical exemption. This apparently seems to work in Burlington. It might work here. The unit owners eventually were required to wear a mask. Mr. Yakovlev, in his submissions, actually stated that his family was aware of the critical importance of following the mask guidelines. So the court on the evidence found that the respondents had failed to comply with the mask bylaw and that such conduct constituted a breach of Section 117 of the Condo Act. And it referred to the earlier decision of HC 77 in Mitrovic. The court also acknowledged that this conduct constituted a risk to the health and safety of other residents and the staff of CCC 32. And when you talk about involving risks to staff, you sort of branch out from the Condominium Act and you branch into the Occupational Health and Safety Act and obligations that are contained in that piece of legislation. So the court has taken an evolving route through these mask cases. I don't believe we've had any since then, other than the one that my colleague Megan and I dealt with last week. We had a decision yesterday. The part of the order required the occupants of the unit to wear masks, although their conduct was a little more concerning than not wearing masks. If we can, imagine shouting death to everybody when they walk past your unit, shouting some very homophobic things out of windows and sexual innuendos out of windows to anybody that walked past. But the sort of the touch paper or the touch point of this conduct really was their refusal to wear masks on the common elements when they were spotted on CCTV cameras. So all that to say is that the court will grant compliance orders when requested if there is evidence that individuals are not wearing masks, and the court has determined and ruled that not wearing mask is a dangerous condition and can cause a risk and constitute a risk to the health and safety of residents and staff of condominium corporations. Thank you, Patricia.
Thanks very much, John. I appreciate that. And with respect to the case that you just won, what was the order of the court? Was it for just compliance with the mask wearing, or was it also removal of the residents?
It was the court found that the conduct constituted a breach of Section 117. It sort of straight up ordered that the individuals be evicted from the unit because of the conduct and the harassment and the continual death threats and concerning behavior.
All right. Well, thanks for clarifying that. It's good to know that the courts are still paying attention to these kind of elements. So now we're going to go to a poll, and I would like to get your feedback on this. We moved the time of our CondoWise session, and we're curious to know whether or not you like the time. So Justine, are you able to put that poll up? So we'd like to know if you've been to a CondoWise session before, and when do you prefer the sessions to happen? So we'd appreciate your feedback on that. Okay, and if we could close that poll, that would be great. Maybe show the results. And I note that the host and the panelists can't vote, so the lawyers can't advise that they prefer it during the day. Sorry, could you put up the results again? So, oh, good. I'm glad to know that you're repeat visitors, and the evening session is 68% prefer that. So that's great. Thank you for the feedback. We appreciate that. So let's go to our questions that are that have been asked so that everybody hears the answers and we get everybody's feedback. So one question is, does the Condo Corp need to pay for tests for accommodation purposes only for use of essential common elements, elevators, hallways, or is that also the case for non-essential common elements, pools, gyms, etc.? Ashley, do you want to share your response?
So if testing is required to accommodate an individual because of a code protected grounds, such as a medical reason as to why they are unable to be vaccinated or a disability related reason, and the corporation has a vaccine policy in place, pursuant to the policy issued by the Ontario Human Rights Commission, the corporation would be required to pay for the testing. However, that would only pertain to the areas where the corporation has a vaccine policy in place. And at this point in time, if anything, it really would just be the areas the government has sort of tackled in the regulation, although it may not apply to corporations, which would be the pool, the party room, or the indoor pool, indoor pool, party room, sauna, and gym. So not areas like the elevators or hallways at this time.
All right, great, thank you. So if the corporation is going to accept negative tests periodically in lieu of being vaccinated from their superintendent employee, is testing done at the employer's expense or the employee's expense?
Sorry, I kind of misunderstood that question, Chris, when I wrote it. It is at the employer's expense, period.
All right, great. Thank you. So let's go to our unanswered questions. So are signed waivers and proof of vaccination sufficient to effectively allow residents to use the amenities? What about contact tracing and temperature taking, which is spelled out in the regulation? Can the corporation use the honor system and trust that residents will log themselves and respect the rules or policy if allowed to use the amenities, or would someone have to police that they are following the rules? Thanks for the questions, George. That was a mouthful. Ash, do you want to start?
Sure. Okay. Well, sorry, where did that question go?
And answered, maybe?
Oh, answered? All right, I'm going to pull it up again. Sorry. Okay, well, first, any rule policy that a corporation has, if it is not going to enforce it and have the resources to, quote unquote, as you said, police it, then it's not worth, it's really not worth having because you're going to have a difficult time enforcing it later on if you're just letting people do whatever they want. It means nothing if it's not being enforced. That's what the corporation needs to take into consideration. So in terms of contract tracing, temperature taking, waivers, we still recommend that our clients have all of these things in place vis-a-vis the COVID policies that our office and I'm sure other solicitors worked on for condo clients over the past year. So what we're talking about tonight is supplementary to those existing policies in place. So all those policies and proactive action should still be followed. Now, if your corporation doesn't have the resources to quote unquote police, I believe as Julia mentioned, see if you can disable fobs so that you can have a control access to the gym to ensure that people are complying. Julia, Patricia, do you have anything to add to that?
No, I think that was pretty comprehensive, actually. And I think it's, I'm sorry if I missed this, but I think that the waivers should put the onus on the unit owners to update them, right? That it shouldn't be on the corporation to police it, because that's too hard to do. But I think it's more important that you put the onus in the waiver on the unit owner. Okay, so do you foresee any issues with in-person AGMs, with some residents not being able to attend due to not being vaccinated? Thanks for that question, Chris. Who would like to take that one? Anybody?
I'll answer it if no one else
All right.
wants to.
Yeah,
But
go ahead. Go ahead.
so I'm almost thinking that we might be looking at a hybrid model going forward, just because of people are going to have COVID PTSD potentially. So yeah, I think with right now, if you are not vaccinated or you do not have a medical reason as to why you cannot go into a conference center, you're not permitted entry at this time. So yes, that could be an issue, but I think condos might be creative in how they provide meetings going forward.
Yeah, I would agree, because I think that you need to think about whether everybody has access to their own AGM. And now with technology, you could always have Zoom on or somehow facilitate both elements in the same space. So I think the objective should be like, are you ensuring that you can have everybody attend in a variety of forms while the restrictions are in place? Another question is, how can a condominium continue to charge maintenance fees and restrict access to owners who own those elements? Oh, that's a good one. But I can start that one off. Well, you have an obligation to pay your maintenance fees under the Act. That is just whether you use it or not. And this argument came up before the pandemic, because some people would say, I'd like to reduce the common expenses I pay because I don't use the gym. And that's just too bad. Unfortunately, the Act doesn't see it that way. They see condominium owners as participants in a collective community, a designed model where everybody shares in accordance with their percentage allocations under the Schedule D of the declaration. So that's really where the authority comes from. if we're restricting access, our costs also may change and fluctuate because we may not be, there may not be an increase in cost. But with COVID, we've seen increases in costs. Even if you're going to use the amenities, you have to sterilize or clean frequently. So I think it's just part of the dynamic of a condo. And I don't think a court would ever say you're entitled to a reduction in your common expenses. So we have a follow-up to a previous question. If a person does not have an exemption, but does not want to be vaccinated or provide their vaccination status, does the Corp have to pay for the test or must the individual pay? Oh, I'm going to say the individual has to pay. Ashley, what do you think?
Yeah, and this is sort of related to Bill's question, which was why should the corporation pay for an employee who's not vaccinated due to personal choice and not a medical exemption? So if it's their personal preference, they do not want to be vaccinated and they are not entitled to an exemption under the code, then yes, arguably they should pay for the cost of the test themselves.
You're hesitating.
So they should pay for so I was just looking at the questions. They should pay for the cost of the test themselves. However, if it's a condo and it's a rule and it's relating to use of the amenities, in order to make the rule more reasonable, if the negative testing is provided as an option, perhaps a condo, in order to make the rule more reasonable, would pay for the testing. However, that's more of a business decision and it's up to the corporation, but there would be no legal reason that would require that the corporation do so if there was no code exemption.
And I would think that picking up the cost would not be reasonable. For myself as a unit owner, if somebody chooses not to get vaccinated, they can pay for their own COVID test. It shouldn't come out of my budget as far as I'm concerned. I think it would be unreasonable. But they pay for use of the
amenities.
So what? They're making a choice not to come in, not to get, they can pay for the test. If they want to use it, the point is they can. It's not that they're prohibited. It's only if they're prohibited, if they show that they have COVID, they're not going to go in. That's a personal issue, right? Even answering the question is a personal issue. So I think it's unreasonable to expect me to pay for somebody's COVID test to use the common expenses, common elements. John, Julia, Shannon, any other thoughts or opinions?
Oh, sorry, Patricia.
Sorry. Again, John, that's twice.
I know.
Sorry, Chris's question regarding the AGM, Patricia, I think you might want to address that given that was released today.
Oh, yes, right. So on the AGM question, I agree, Chris, the hybrid model is the way to go. But just so you know, that bylaw deadline of December 31st for electronic voting and electronic meetings was extended. It's actually going into 2022, and I think it's
September.
What was the date? September, I believe it is. But we're going to have an e-blast out on that tomorrow from our team just to confirm that the date has changed. So really, everybody should be ensuring that their AGM packages has that electronic voting and electronic meeting bylaw in it. Get it approved so that you're in good shape, even when the element of the legislation expires. So everybody, thank you so much for being here with us. We appreciate your time in the evening, and we appreciate our team being here as well, away from their families and their other responsibilities or leisure time. Stay well. Remember, we still have a pandemic to manage, and anything that, thank you, MTCC 555. It says it's extended to September 30th, 2022. And we'll keep you posted. Our COVID bulletin, our next one is out tomorrow. So we'll keep you updated as soon as we know, and the more thoughts we have, we'll share them with you. So take care and good evening.